Welcome everybody, and thank you everyone for joining us today. My name is Marie Kilgallen and I'm a Senior Associate here at Owen Mitchell, and today we're going to give you an update on pensions on divorce. Thank you very much for joining us. I know it's a tricky time of year with holidays and children breaking up from school, etc. So it is great that you can join us today. Just to do a round of introductions. So my name is Marie Kilgallen, as I say. I'm part of our national family team based in our Birmingham office. I'm joined by my colleague, Alex Schippers, who's an associate based in our London team. You can't see these people yet. They will appear as we start our discussion, but they are on the slide in front of you. I'm also delighted to be joined by three experts dealing with pensions. The first of those is David Venn, who's a chartered financial planner with Kingswood. David's got 20 years experience with long-term care planning, retirement planning, investment planning, and I'm pleased to say pension transfers and pension investments. We're also joined by Jonathan Galbraith, who is CEO of Mathieson Consulting. Those of you who've joined us today are in the family law world will probably already know Jonathan. And if you don't, you probably should know Jonathan. He joined Mathieson in 2017. He has a wide knowledge of pensions, involved in a lot of high-profile cases, and really is at the coalface of developments in pensions on divorce. And he's going to take us through something that he crafted, which helps us dealing with pensions on divorce, called the Galbraith tables. And last but certainly not least, we're going to be joined by Rhys, who is a barrister at 36 Family, an arbitrator, mediator, sits as a recorder. He contributes to the Red Book, which is the Family Court Bible, a member of the Family Procedure Rules Committee, and author of publications dealing with pensions on divorce. And so we are in definite pensions company with our experts today. As we go through, you have the opportunity to ask us questions. There's a QR code on your screen at the moment, and if you either use the hashtag or you scan that, the questions will come through to us on an app called Slido, and we can answer them as we go through. Before I begin, a little bit about our Owen Mitchell National Family Team. So, as I say, we're national. Our offices are based in Leeds, Sheffield, Manchester, Liverpool, Bristol, London, Birmingham, Chichester, Southampton. I'm sure I've missed a few out there. Cardiff, Liverpool, perhaps. So we are truly national. We're over 100 strong, including our fabulous support team, and we work nationally. What that gives us is not only the regional presence when we're in our own offices, but also it means that we have access to experts and specialists across the country and can really offer our clients a service that they need where they may live. So, as I say, we're national and we're strong in what. One of the things that I really wanted to talk about and go through really, Rhys, with you perhaps, Jonathan and Alex, and to have a conversation about is negligence and risk areas, and really to talk about the case of Lewis and Cunnington, which is a case that really, when I read, and I know our team read, it literally changed our practice. So, Rhys, could I ask you to run through Lewis and Cunnington and what impact that's had?
Yes, of course. Good afternoon, everyone. Can you hear me?
Yep, we can.
Good. Okay. So Lewis, the Lewis case is a case of general applicability when dealing with divorce, but it's played out through the medium of a problem with a pension case, and that's why we're talking about it. So in this case, we have a long marriage. And the assets were very modest indeed, but the husband had a substantial police pension. The wife, on presentation, and there were some flags in the way in which she'd come across to her solicitor, appeared to be vulnerable and to have been a victim of bullying and intimidation by the husband. Now, excuse me, should have been obvious, or would be obvious to just about any family solicitor, that the wife would have had an extremely substantial claim over the husband's pension, there being no other assets after a long marriage. But she was of limited means and didn't ask for a sort of general retainer. She was giving very limited advice indeed. She was told there was such a thing as a pension sharing order, but she wasn't told how they would work or the implications of how they work in the context of a police pension, which is very familiar to family lawyers. She didn't instruct her solicitor to seek disclosure of the husband's circumstances, and they had a retainer with the following wording. It says this: I confirm I have been advised that there should be an exchange of full and frank financial disclosure before my solicitors can give me any advice in relation to suitable financial settlement options. I've instructed my solicitor that I do not wish for there to be an exchange of full and frank financial disclosure, and I accept I have not been given any advice in relation to possible settlement options. I understand that I'm going against my solicitor's advice, and I confirm that I wish to proceed in the absence of full financial disclosure. Now, subsequently, in the negligence action against the solicitor, the court found that this was an inappropriate one-size-fits-all form of retainer. And the wife was led to believe on the back of that that in fact she couldn't ask for advice about other aspects of her claim, having had that retainer sent to her. The court did not accept that the wife had specifically instructed the defendant's solicitors not to seek disclosure from the husband. She simply at that stage hadn't required them to do so. And the court concluded that as the pension in this case was by far and away the largest asset, it would have been almost a certainty on the facts of the case that a pension sharing order would have been made. And the wife should have been advised in the clearest possible terms that she was able to pursue the pension. And the defendant's solicitor's general reference to pension sharing orders as a possible remedy wasn't enough. And so on the back of that retainer having been sent, there wasn't a full disclosure, and the solicitor simply didn't explain to the wife what the issues are with a police pension, and he'd been in service for a long time. She went off and one rather expects was bullied into an awful settlement of only £62,000, a woefully low settlement in all of the circumstances. She then returns to her solicitor and asks them to implement a draft order which has been agreed between her and her husband. And at the point that the D81 was prepared, that showed that the husband's pension was extremely valuable indeed. And again, at that stage, the solicitor still didn't advise the wife. The judge hearing the negligence case referred to the Court of Appeal case of Minkin and Landsberg, a case which will be familiar to many family lawyers, a 2016 case. Very briefly, in that case, Lord Justice Jackson said, a solicitor's contractual duty is to carry out the tasks which the client has instructed and the solicitor has agreed to undertake. It's implicit in a solicitor's retainer that he or she will proffer advice which is reasonably incidental to the work that he or she is carrying out. In determining what is reasonably incidental, it's necessary to have regard to all of the circumstances of the case, including the character and experience of the client. In relation to the point I've just made, it's not possible to give definitive guidance as the Court of Appeal. One can give fairly bland illustrations. An experienced businessman will not wish to pay for being told what he or she already knows. An impoverished client will not wish to pay for advice that he or she cannot afford. An inexperienced client will expect to be warned of the risks which are or should be apparent to the solicitor, but not the client. And that's exactly the situation that we had here. There's also, very briefly, a further case referenced, the case of Credit Lioness and Russell Jones and Walker, in that a 2002 case. And in that case, Mr. Justice Laddie said, normally the solicitor only has to expend time and effort in what has been he's been engaged to do and for which the client has agreed to pay. He's under no general obligation to expend time and effort on issues outside the retainer. However, if in the course of doing that, for which he is retained, he becomes aware of a risk or a potential risk to the client, it is it's his duty to inform the client. In doing so, he's neither going beyond the scope of his instructions, nor is he doing, quote, extra work for which he's not being paid. He's simply reporting back to the client on the issues of concern which he learns as a result of and in the course of carrying out his express instructions. And so what should have been apparent to the defendant's solicitors in this case is that they had a vulnerable client who didn't understand how divorce settlements worked. Although they didn't have full and frank disclosure, they knew that there was a long-standing police officer who would have a very substantial pension, and it would have been very easy, without obtaining full and frank disclosure, to update the client and to advise her in strong terms as to the likely outcome of that kind of factual scenario. The court did make clear that had they done that, and the client still then wished to ignore their advice, they could have had a limitation of liability or retainer clause that would have been effective at that stage. But they didn't do that. That it was simply a one-size-fits-all, off-the-shelf clause, which really didn't meet the needs of this case. And so the claimant was successful in the claim for £400,000 worth of damages and the costs which would have been associated with that. So a very significant warning in the market in which we operate, particularly with unbundled services and the like, that you need to think very carefully about what you're doing before you before you start seeking to limit your liability.
I mean, I'd like to think, Rhys, that had that case come across my desk, that I would have certainly highlighted it, and I'm sure that's what we'd all say. But Alex, from our perspective, how did this case change what we do in practice day to day? How have we tightened up?
Well, I think we at Owen Mitchell always tended to take quite a careful approach anyway, in ensuring that we advise clients appropriately based on the information presented to us. But I guess the problem is, and Rhys, you touched on it, often clients don't really know what advice they need when they come to us. Going through divorce and discussing financial settlements is obviously a totally new process for a lot of people. And as a result of that, it's not uncommon for them to feel overwhelmed and vulnerable. And obviously that was a consideration in the Lewis versus Cunnington's case. But I do think that the judgment in this case kind of hit home for a lot of us. And following the judgment, we've kind of changed some of our own practices, which we did kind of almost instantly, to be honest, to make sure that we were working in line with that guidance. And we've adopted new policies, especially where pensions are involved. I think historically it was sometimes thought to be the case that if a client signed a waiver, then that was the law firm protected, and any kind of subsequent financial loss was almost kind of the client's fault. It was sort of a tick box exercise, really, which feels wrong now looking back. But I think the key shift more recently is that a waiver itself obviously doesn't protect against a negligence claim, and it must be accompanied by thorough and tailored advice. So I would make sure we obviously just think it's imperative really that the client is advised appropriately so that they understand what they are giving up on or potentially giving up by taking the proposed course of action. So I mean, in this case specifically, obviously Cunningtons did advise Mrs. Lewis that the court had the power to make orders in respect of pensions, but that sort of generic advice just didn't go far enough in warning her about what she could be conceding on in reaching the agreement directly with her husband. So like I say, really it's just about ensuring for us that even when a client decides to take the route of reaching a direct settlement and signing a waiver, we still give tailored and comprehensive advice so that, like I say, they know kind of what claims they're giving up on in doing that. Jonathan, obviously you were involved in this case, and so it's really exciting to have you with us today. When you advise on cases of this nature, does the negligence, do you find, tend to arise from the parties not getting a pension report, or is it them kind of having signed a waiver and then they've received poor advice from their lawyer or their financial advisor, or, I mean, is it a combination? What do you tend to find?
Thank you, Alex. Yes, indeed, I can declare an interest in that particular case, as I served as an expert witness on the side of the solicitors who were defending the claim, and that's one of the things that we do. We do get involved with negligence work of this nature. We will only ever work for the solicitors who are being sued rather than the claimant. I think it'd be commercial suicide for us to do otherwise, quite frankly. Yeah, in terms of what we see, we've seen quite a few such cases. They are almost always around offsetting rather than pension sharing. It comes down to there's been some attempt to do some sort of crude form of offsetting where a report hasn't been obtained, or, for example, the CEVs have been used for offsetting purposes, and that tends to have then turned out further down the line that this was a failure to consider the true value of some of these pensions. So, I mean, to the extent that we get involved in these things, we will not comment on the legal points as to whether what was done was right or wrong, as it were. What we're getting involved in really is more about trying to place a fair value on the benefits that could have been said to have been foregone. In other words, if this case had been settled via pension sharing back in the day, what would wife have wound up with at that point, and what might she now need today to compensate her for that? And then, of course, there will be someone advising the claimant as well, and we're really then trying to find what is a fair value, where it to be found that the solicitors were in fact negligent. I think most of the cases that we tend to see predate 2010. I think it is one of these things that by the early 2010s, increasingly, I think the practices that were being adopted by solicitors probably were as they should have been, and it is these earlier cases that tend to give rise to these things. But there are some that are more recent. And I really think I just want to touch on what you said there, Alex, and I think that the lessons that to be learned from this case perhaps are do disclaimers protect you as a solicitor? I suppose it depends what they say in the terms in which they've been signed. Who in the end bears the blame for a poor settlement? Is it simply the solicitors, or it must be remembered the solicitors on the other side, and there's of course a court making a decision here. And can you argue that what we did was the custom at the time, which is effectively the Lance Armstrong defence? And I think perhaps the lesson to be learned is that one doesn't really help you. So I don't know what the answers are to all these questions, but these are certainly some of the issues that come up as I saw on that one.
Thanks, Jonathan. I think one of the reasons why we've got yourself, Jonathan, Rhys, and David, who'll join us shortly in relation to pensions, is that it really should be a team approach. And one of the cases I want to remind people about is the case of TNT, which is a decision by His Honour Judge Hess. And actually, I'm not going to go through the judgment because it's quite long. It's actually the postscript to that judgment, which is quite important for practitioners. And what that judgment talks about, it was a case where the parties had a pension sharing order and took a very long time to implement it for various reasons. And during that time, the pension value went up due to actuarial factors. And there was also issues about the scheme potentially being underfunded or not underfunded. But when you are completing a pension sharing annex, there is a section on the back of the form which asks whether or not the person who's receiving the pension credit, therefore getting the benefit of the share, do they want an external or internal transfer? And often we as lawyers or our clients are asked to tick that box. And certainly the postscript to that judgment by His Honour Judge Hess is do so at your peril. And that is the point at which I would bring in, if you haven't already, you bring in your financial advisors, because your clients, if they're getting a pension credit, should absolutely be getting advice at that stage on what they're investing, the terms of the scheme, external and internal transfers. It's not a decision for us to be making. I know sometimes, Jonathan, you do comment on that in your reports, but ultimately it has to come down to the client getting that advice.
Could I chip in with two quick points there?
Absolutely.
One is that we've got the new template in the suite of financial remedy orders, and one of the new sub-clauses of that template provides for the parties to use their best endeavours to implement the pension share as quickly as possible, and that hopefully will cut out some of the problems. You know, you do have people who don't want to cooperate, and then you have people who just take the annex home and put it in their top drawer and forget about it for 15 years. And so the new annex stops that. The other thing as well, you raise a very important point about involving financial advisors, and you said certainly at the stage that you've got your order, get a financial advisor involved. There will be many cases where it would be appropriate to get the financial advisor on board sooner. And a particular complexity you have is with SAS pensions, which are quite often holding illiquid commercial premises from which family companies trade. And if you're only bringing in your financial people by the time you've got your order, you've probably got the wrong order. And so there are some circumstances where the complexity of the pension is such that you need to be talking to your financial advisor right at the outset as to what can we do and where can we find liquidity in the pension. We're used to doing that with other assets, but it can apply to pensions as well. And how are we going to make this work? And sometimes a stitch in time saves 9.
Absolutely. I'm going to try and join David now and see if our tech works. See if David can join and just get his comment really. Certainly it's our practice, even at the initial stage when we complete Form P, we certainly advise clients to get their advice. David, can we hear you now?
Hopefully. Does this work?
You can, David, thank you.
Perfect.
Do you want to just comment on Rhys's point about involving financial advisors?
Yes, getting in from the start of the case is much better for us and for you, and also for the client who's really driving where they want any potential pensions to go in the future, but also looking at any of these complications in the background, like commercial property within a SAS, like whether they can stay as a member of an occupational pension scheme and have a shadow membership and things like that as well. So we can really guide the client based on their objectives and their attitude to risk. But we're also bound as financial advisors by the new Consumer Duty Act that has come in, that makes us focus, and if we weren't already, I'm sure a lot of us were, focus on the best possible outcome for that client. You know, not what's best for our fees or our retainers or where we want to put the clients. It's the best possible outcome for that client. How are we going to achieve their goals and their retirement objectives, whether they're losing money in the divorce or gaining money from the divorce within their pension fund?
Thanks, David. That's really helpful. So if we're talking about negligence, perhaps we can move on to the first thing that we do. So we've talked about getting the pension information in together. And a question we've had in, Jonathan, which is a question I expected to receive, quite frankly, which is, in light of this guidance, which sort of strikes fear of solicitors and no one wants to have a negligence claim, what is the threshold for needing a pension report? You know, are we still going with the PAG 1 guidance? What value, what circumstances? Can you help us with that?
You're muted, Jonathan.
Sorry, I should know by now after all these years. Sorry. I think what's in the PAG report is pretty good in this. The point that has to be understood though is there aren't too many hard and fast rules. These are the rules, but for the exceptions, if you like. So, and I think first up, if it's all defined contribution funds, so these are the kind of pensions that we tend to have these days outside the public sector, and the parties are close in age, then there's an argument that there isn't really a need for a pension sharing report. But you would want to be comfortable that there are no guaranteed annuity rates that attach to these defined contribution pensions, as they provide in many cases, some quite significant additional amounts of value. How can you be sure that there are no guaranteed annuity rates? It should say in the paperwork that accompanies the pensions. I think it's fair to say nobody has written any new guaranteed annuity policies since Equitable Life went up, which is, let's just say, around about 2000. So any policies that have been taken out after, say, the year 2000, you can say with some confidence that there aren't going to be any GARs attaching to them. There might be attaching to older policies. If the parties are young, one of the things I love about this industry is that young seems to be defined as being about 50 and very young seems to be defined as being under the age of 40. But if the parties are in their 20s and 30s, then it's likely that the pension benefits that they will have will be modest, and under such circumstances it's less likely that one would need a report. But the important caveat to that is if the parties are in any of the uniformed public sector schemes, so police, armed forces or firefighters, as those pensions are very generous and give very generous early retirement terms. You can become a pensioner in some of these schemes in your late 40s, and it follows then an entitlement to a pension payable from, say, 47 is going to be very, very valuable, rather than one payable from 60 or 65. If the pensions are modest in the context of a high net worth case, so if the total assets of the case are between 30 to 50 million and there's, say, £1 million in pensions, then you wouldn't necessarily ignore it, but would it necessarily merit a special treatment? Probably not. That could probably be included as a pound note amount to be considered alongside the other assets. And then again, if the pensions are de minimis, that is of course a very difficult term to define. The PAG report refers to CEVs of below 100k. That is perhaps a good rule of thumb, but it's difficult. These cases perhaps do need to be considered on their own individual merits, and perhaps it's about looking not just about the totality of pensions, but how much of a gap is there in the pension amount. So sorry to be a little bit vague there, but these are, if you like, the rules of thumb when it comes to this.
Thanks, Jonathan. And then Rhys, you're on both sides of the coin, so to speak, in that you're often asking for pension reports, but also you sit as a member of the judiciary, and expert reports are meant to be necessary and proportionate. Is there ever any pushback on obtaining pension reports? Perhaps the big value cases Jonathan's mentioned.
Yeah, so clearly there's a big debate at the moment about the necessity of pension reports coming out of the Mr. Justice Moore decision last year, CMX, and the really big cases, as Jonathan says. Once you've got 26 million, £1 million pension isn't really going to make that much of a difference. So one's looking at relevance and proportionality. The law of unintended consequences. I think the PAG reporters come in for some stick that people, or its critics, have sometimes said, well, it's demanding that a report is obtained in all cases, and it's not. But I think whereas historically, perhaps in the run-up to when PAG started its work, which was a couple of years before 2019, there was too much of an emphasis of, oh, well, we don't need to worry too much about that. I think now perhaps people have become over anxious and are asking too often for reports. And when you look at them, you could say, well, look, do you really need a report here? And I can think of a number of cases where it hasn't been necessary if one just stood back and looked at the nature of the pension, the length of the marriage, the proportionality of it in respect of everything else, and so it does really depend. But I think you do need to engage the brain and ask yourself, well, where does it fit into the overall picture? When one looks at the overall picture in financial remedies, we have all been taught since we were in short trousers that financial remedies paints with a broad brush. And so sometimes I think there's an overcomplication when it comes to pensions. It is still possible to have a standing back and looking at the woods rather than the trees. So it's a sort of hedgy answer, I'm afraid. It all depends on the individual facts of the case. But certainly the very big cases, it's most unlikely now that you would get a pension report, certainly in cases proceeding in the family court at high court level. In the more middle class cases, I think it's more likely that it would be necessary, because even a substantial pension asset, rather depressingly, yields a relatively modest income if taken at 60, say. And so you do need to know the income consequences of that in order to decide what you're doing with maintenance, term of maintenance. Are people going to starve in retirement and things like that? So it is necessary in a lot of, if I can put it this way, everyday ordinary money cases.
Thanks, Rhys. And Alex, looking then, ironically, the cases where perhaps there is more wealth, they probably don't need the cost of those pension reports. But in cases where costs are more likely to be an issue, it's more likely to have to spend that cost. Just talk about the proportionality of getting a report and the cost of those.
Yeah, I think, the cost is another, highly relevant factor that we have to consider, really. Often when clients come to us, they've never really heard of a pension report, and it's not necessarily a cost that they've budgeted for or anticipated. So it can sometimes come as a bit of a surprise to them. I think as practitioners, our preference would obviously be for clients to, almost always get a pension report, because it puts us in, a much kind of safer position to advise them. But you also can't ignore the issue of cost proportionality, which is kind of more prevalent than ever at the moment. And I think we're finding that there's quite a fine line between advising a client to obtain a report because, in an ideal world, you'd have one. It kind of makes our job easier. And, we prefer to advise based on having that information against them actually needing it, and the pensions in the case kind of justifying that expenditure. So going back to what Rhys and Jonathan were saying, really is quite a fact specific kind of consideration, isn't it? Whether or not you kind of expend that money on a report or not.
And then, Jonathan, perhaps moving then to the Galbraith tables, which is, you've talked about offsetting being a negligence risk. And if you haven't got a pension report, and we are adopting a broad brush, sometimes you are tempted to look at the schedule of assets and say, well, you keep that, and perhaps you have a bit more of that. There's no science behind that, but you've tried to create some science behind it to help us. So do you want to just explain to us what they are?
Certainly, thank you. Yes, I think I'm just going to chip in there with regards to the point of getting a pooled report. I think the figure that's always banded around is there's around 100,000 divorces go through the courts every year in England and Wales. I would estimate that the absolute maximum number of pension and divorce reports that are being written can be really no more than about 5,000 a year, and I would guess it's quite a bit less than that. So there's a huge number of cases where there are no reports, and again, in many cases, for the reasons we've discussed, it will not be necessary to have such a report. But it is that thing that if you don't have a report and there are some pensions of some significance, how else can you look at valuing these pensions? What else can you do as a practitioner? Well, you can look at the cash equivalent values of the pensions, but that doesn't always give a fair value, which is, again, the issue that often comes up in negligence. And so with that in mind, we had a go at trying to create some tables that could be used for valuation purposes. So my colleague Chris Goodwin and I came up with the Galbraith tables. I certainly came up with the name, and these are now published in this wonderful document, being At a Glance. So the purpose of the tables there is we believe that they are useful in deriving a ballpark valuation of what might be some defined benefit pension rights. So if you've got, if you know that, say, husband is 50 at the moment, and is due to retire at age 60, and the pension's payable from 60, you can then look up a multiplier in here, and there's a figure there of 29.57. And really what you're saying is that every pound per annum of pension that he is expecting to receive in retirement is today worth £29.57. And therefore, if you've got details of the parties' pensions from your clients, it should be able then to do just a little bit of rudimentary analysis to work out roughly kind of what ballpark are we talking here. And I think that that's helpful for comparing the parties' pensions with each other to see who has the greater level of pension rights, for doing some comparisons with the other assets that might exist in the case. And then I think it's also quite useful for, we're often asked to consider things like offsetting, whereby the parties retain the pension rights and the non-pension capital is adjusted. And I think it might be quite useful to understand what broadly are the value of these pensions, and do the non-pension assets exist to do any offsetting? You know, if the pensions are worth £500,000 and they've only got £100,000 of equity in the house, then offsetting isn't going to happen because the assets don't exist to do that. So, I mean, we very much take the view that are these tables perfect in every single case? Can they be used in every single kind of pension? Probably not. You will find the caveats in at a glance, and you'll find even more caveats if you go into the full document that accompanies the tables on our website. But we do genuinely believe that they are better than simply relying on the CEV, and if they are helpful for practitioners, then we've done our job well, quite frankly.
Could I chip in from a legal perspective? These are potentially game-changing tables for understanding a pension. Sometimes we talk about kicking the tires, getting a feel for what you're dealing with. The PAG report will say, I think, it's yet to be finalised, but I think it is likely to say that they are a good starting point in understanding the value of pensions. And I think that the very fact that they found their way into at a glance would suggest that they're viewed benignly in high places. There's yet to be a contested case about them at a final hearing. I think there does need to be a high-level judicial determination, but one senses that if they found their way into the at-a-glance tables, that there may be a fair wind behind them, but they do come with caveats.
Yeah.
And so you do need to understand that simple figure that it churns out, you just run your finger along the table. It's very easy to use. But that figure is based on the assumptions in that table.
Correct. Yeah.
And so I would suggest that in many cases it's good at understanding the pension value, very useful in bringing to the courts, the parties' attention, coming back to the point about the negligence case, the potential value that they're giving up by not pursuing pensions. They may also be used in the mediation context, and I think probably up to and including FDRs. We await a judicial determination for the context in which they may be used beyond FDRs. I think the other point which is worth flagging is that they do render a very different outcome to the Duxbury tables. The underlying assumptions in them are quite different. Yep. And because I've had the privilege to have seen them in draft and to have been involved watching them develop over a period of time, I've been quietly, in cases, scratching out a Galbraith answer alongside more traditional Duxbury answers. And it does give a different outcome. And so I think there will come a moment where that sort of people cotton on to that. And, people will be saying, well, you say Duxbury, I say Galbraith, and it'll be very interesting in the pension context to see how that plays out.
I absolutely agree with you, Rhys. I think practitioners, we use them, and certainly Jonathan, you've given training to our national team on them, so we have used them. But I do find often if I use them as a sense check, perhaps to negotiate, that the other side may not have used them or have any confidence in using them. And I say that not as a criticism, just as I think if we had some judicial guidance on them, perhaps they'd be more widely used as a really helpful tool that they can be.
And if you have a client of limited means, and they simply cannot afford to get a report, then I think the way that you would have to try and cover yourself off is to make abundantly clear that this is a tool. It has a set of assumptions. They're reasonable and soberly crafted assumptions from a leading expert in the field, but they will not be definitive in all circumstances. And so a lot of the uncertainty that abounds around them can be covered off with a couple of wise sentences in an attendance note. We're all really familiar in the context, say, of company valuation, that it's a valuation, and another expert may say something else, and so providing people understand what it is, I think they're very useful.
Absolutely. I've had a question actually, Jonathan, come through, which is, what are the name of the tables and where can they be found?
The tables are the Galbraith tables, named
And
after
your
my
name's
good
on the
self.
screen.
Gotcha. And you will find them, as I said, you can be found in at a glance. And also, if you go onto the Mathieson Consulting website, you can download the document there. And they're also, if you have your inaugural copy of the Financial Remedies Journal, you'll also find them in there with a bit of a commentary that goes with it.
Could I mention, so far as the Financial Remedies Journal, of which I am the editor, that's available for free download off the financialremediesjournal.com website. And so the full user manual that Jonathan has on his website is pretty, suitably in depth. And I like to think of the article in the Financial Remedies Journal as a quick start guide. And so if you're trying to understand the context of it, I would go to the text in at a glance, and I would go to the quick start guide in the Financial Remedies Journal website.
Thank you.
Wonderful.
So turning to you now, David, if that's okay. Just a question, if the parties kind of don't obtain a pension report for whatever reason, whether they're advised that the facts don't fall into those categories or they're advised to get one and they just decide not to what extent can financial advisors still kind of help and add value to the case, and at what stage?
Yeah, I think coming into this early on is always a benefit because it helps the clients. But we are there as the facilitator at the end of the day to achieve their goals. We cannot comment on the merits of the values put before us. So this is why we would go to the Galbraith tables as a guide, but get a full report done to really look deeply at the client's circumstances. But if they're saying that they don't want to report, then what else can we do? We really need to look at the client's position and their knowledge and understanding of pensions in general. We find that knowledge is quite limited when it comes to pensions. Nobody really understands how much they need to have invested to generate a particular income in retirement. And we also need to understand their vulnerability as well, because the lack of knowledge can lead to a vulnerability, or they might be in a vulnerable position that we need to really hold their hands through this part of the journey to really understand the value of what they could be receiving, or even losing as well. The financial advisor will be really focused on the financial and retirement objectives of the clients. And we can use tools like cash flow forecasting to say, look, this is the position you're in now, and this is where it's going to be either at retirement or at a fixed point in time. Using what we know based on the values that we have in front of us and what we may be receiving or losing, this is going to be your anticipated position after the divorce process. And we also can throw in additional elements like, well, does this get you to where you need to be? Is there a chance to refund your pension to get it back to where it was? Or do we need to fund it extra on top of what you're going to be receiving to get you to meet your retirement objectives? Not only are we assessing that, we're looking at the client's attitude to risk, and we can factor that into the forecast as well, to really help us decide whether the client's taking enough risk or not taking enough risk, or even if they're a low risk investor, that we should be taking that into consideration if there's a shadow membership option available within the DB scheme. We shouldn't be considering transferring them away from there if they're not willing to take any risk with a pension fund, because you're moving that risk of income in retirement from the scheme provider to that individual. Are they happy to take on that risk? Do they understand the full ins and outs and ups and downs of potentially what could happen to their retirement fund later on in life? So we need to know all of these things and really sit down with the client to really drill down to, well, this is what you've got, this is where you'll end up, this is your risk level. This is going to help us put the correct strategy and product in place for you, but then also ensure that we're having regular review meetings with them after all of this to make sure they remain on track, and we keep that strategy running correctly.
Thanks, David. One of the points I want to pick up with, perhaps with you and with Jonathan, if you could just explain, you talk about the value of the pension, whether it's a real value. So if you could just explain a little bit about that. And then, Jonathan, I follow your colleague George Mathieson on Twitter, and he's been very vocal in recent months about saying to practitioners, looking at the value of pensions, particularly as they've gone up and down, and how we actually value pensions and get a fair market value, particularly those defined benefit schemes. So if David can just talk a bit about valuing pensions first of all, and then Jonathan, if you can just pick up that point, that'd be great.
Yeah, so when we're trying to value a person's pension plan, there's many different areas and aspects that create additional value. Most of us will have a defined contribution scheme, which is ultimately a bucket of, well, how much have I put in there? What's it grown to? What's the value today? And for defined contribution schemes, it can be very simple, and that is today's value. And assuming a normal market scenario, it isn't going to move too vastly between the date of applying for the divorce to the date of actually getting divorced. There shouldn't be too much movement unless we have a significant market event. And it's important to be speaking to the financial advisor regularly to know whether those market events have happened, because when COVID struck, for example, markets fell and valuations fell by a good 25% in a matter of months. Yes, they recovered very quickly because we were able to throw a lot of money at the problem. But then you come into 2022 and the markets again have changed significantly, and we've seen a significant and sustained downturn in the market. From the start of 22 to the end of 22, most people saw a consistent drop in value, 10, 15% off of their peak. So at what point are we actually pinning our position on the board and saying, this is the value that we're taking for the pension? You then start complicating it when you've got things like final salaries, cash equivalent transfers. How old are the individuals? Is there a big difference between the person holding it and the person that they're divorcing? That can add in, this is where the Galbraith tables, I'm sure, come into play to say, well, let's have a look at that. How do we generate that level of income for this individual in however many years' time? If there's a property involved in there as well, we know that property is getting regular growth through rental income. It's growing with commercial property values. The individual may not want to give up full access to that income and that growth of the property scheme. How do we separate that out? How do we still maintain a clean break in that scenario? Because I'm sure if it was my pension scheme and I have a commercial property, would I want my ex-wife still benefiting from the rental payments that I'm paying from my business into it? How do we define a value from there? So they can get very complex to actually value, but also the timing of that valuation can have a significant effect on there as well.
Thanks, David. And then bringing in Jonathan. Jonathan, if we've got a pension report, perhaps we obtained it at the end of 2022, and we're now, for some reason, only now getting to talk about a settlement, and it's got valuations in, what should we be doing, if anything, and does it depend on the type of scheme?
It does. An excellent question. I think I would echo everything, David, that you've said there. Absolutely right. We've seen quite a bit of volatility in the markets, and in particular, the valuations of pensions will have dropped quite a bit from the peak in what maybe about a year ago, summer 2022. And I think to that extent, if you've got reports that are based on CVs that are dating back to the summer of 2022, then almost certainly you want to have those updated. You might see some quite substantial falls in the valuations of those pensions. I think that there's a number of implications for that. I mean, it may well change the advice that's given in terms of which pensions are best placed to be shared. If the husband in the case has substantial defined benefit and defined contribution schemes, then the sharing of defined contribution pensions is always done on a fair value pound for pound basis. But what wife gets where a defined benefit pension is shared, where the share has to be implemented externally, it's very much a function of that ratio of the cash equivalent value to the underlying pension rights. And it may well be that this is a very generous CEV and that sharing this pension actually generates wealth to the advantage of both parties, or it may well be that the cash equivalent falls below what we regard as the fair value and value is lost where it's shared. So I certainly suggest that it makes sense to have reports updated. Where one of the parties, I'm assuming the wife is the one who's receiving the pension share, if her pensions aren't being shared, then it wouldn't necessarily make sense to have the values of defined benefit pensions that she holds updated. It would always make sense to have the values of defined contribution funds updated, as that's free and easy in almost every single case. That all you need to do is get your client to log on to some portal and print out some valuation and then give it to the POD. But as I said, it would make sense only really to have the valuations of defined benefit pensions updated where we are looking to share those, I would say.
Lovely, thank you. And then we've talked about PAG1, and I'm conscious that's a terminology that people may not have heard about. And we're waiting PAG2, and certainly Rhys and Jonathan, you're both part of that. I don't know, Rhys, do you want to just explain a bit about PAG1 and PAG2, and perhaps Jonathan as well chip in about what we can expect from that? Certainly, if you haven't read it and you're practicing family law, I'm really sorry to say that you should make it bedtime reading. It is heavy going, but you absolutely should make it bedtime reading. But PAG2 is coming, and what can we expect from that?
So very briefly, PAG1 was a gathering together of an interdisciplinary group of people. I work in my silo and I understand how the law works, but I don't understand the actuarial aspects of pensions in the way that Jonathan does. And the idea of sitting us all down in a room together and sort of hot tubbing us all together at the same time so that we could share our different silos of learning and pull it together in one document. That's essentially what PAG1 was about. You refer to its complexity. Can I also commend a document produced by Law for Life Advice Now, which is a charity which provides guides for people who can't afford legal advice. And they have written an absolutely brilliant litigant in person friendly version of the PAG report. It really is. It's a straightforward, simple read, but it explains in simple terms how to understand pensions. If you're against a litigant in person in a case, send them a link to that document. It's available as a PDF to download, or can be purchased for a very modest sum of money. I've joked several times that if the PAG report and the Law for Life report were both drowning, I would dive in and I would save the Law for Life report, because I think it's probably got a wider use to a wider group of people. Be that as it may, the PAG report was published in July 2019. And so what we thought we'd do, life having moved on a bit since 2019, lots happened in the world since then, we thought we'd just have another look at it. And so we're not completely rewriting the whole thing from scratch. It's in the nature of a further version of the PAG report, but there are bits and pieces that we thought would be helpful to tighten up. We've had a steady stream of correspondence since 2019. I'm bound to say most of it is complimentary, but we do have our critics, and we're going to try and address some of the critical observations. One of the, I think, unfair criticisms that is made of the PAG report, that it is said that we imply that even in a short marriage, there should be equality of pension income in retirement. And the PAG report, PAG1, doesn't say that, but we're going to make it more express that in relation to short marriages. We're also going to deal with the Galbraith tables and how they might be used, and whilst they're cautiously commended, also referencing the care that needs to be taken in understanding the context in which they can be used. So we're actually having a meeting this evening. Jonathan and I thoroughly fed up with one another's company by now, or he'd be fed up with mine anyway.
Not at all, not at all.
And so we're hoping that we're moving towards a final draft of the document, but there's still, I'm afraid, some panel beating to do, and the summer is upon us, so we're probably looking not until November or December until it will see the light of day. But certainly a reconfigured PAG group. There's some people who were on the first one and then some new contributors have been working very hard to update and hopefully provide a new guide that will be refreshed and will be of continuing use to practitioners.
Wonderful. I mean, certainly I'll be reading it, and it's fantastic to have that as a resource. I think one of the questions the question I've been asked throughout this actually is, David, it's to you really, but I think perhaps you've answered it, and I think perhaps Rhys, you touched upon it when you talked about us all operating as silos. And the question I've been asked is, where do financial advisors add the most context, David? And I think you've talked about that being at the start, but actually throughout.
Yeah, I think financial advisors really help the clients to understand what it is they're looking at. The pension is something that's always just sat in the background, and people have been almost sleepwalking to retirement. And so they get to the point of either being pleasantly surprised or unfortunately shocked by how much or how little income is going to be generated by the pension funds. So unfortunately, only 10% of the population is actually receiving financial advice. The industry is not geared up to be able to financially advise absolutely everybody to retirement. So it's getting that better understanding, that knowledge out there. People are looking at pensions probably for the very first time in their divorce. And we're able to help them understand what it is they hold, how valuable that pot actually is, and what can be done either if you're giving up the pension or you're receiving the pension, and why it needs to be done as well. So just
certainly what strikes me is that, we've talked about, going back to our very first point about the Lewis and Cunnington case, which is we can all do the best job we can do to help our clients, but actually we really need each other. We really need to work with everybody together.
Could I chip in with a thought? And it's this. I'm in a very privileged position because of the work I've done over the last few years. I've got lots of the leading experts on speed dial, and I can make a nuisance of myself, and I can ring people up and say, oh, can you just help me with this point, please? I don't quite understand it. But I think, having been immersed in the work in the way in which I have, I do have a confidence to know the limits of my knowledge and to know the things that I really I can't be expected to know. Now then, please don't take this next comment as a criticism of Resolution. I think what Resolution is doing is marvellous, but they put a financial planning conference on, and they get financial planners together talking about the financial aspects of divorce, including, importantly, pensions on divorce. But I think one of the things that possibly, not intending to be critical, where the trick is being missed, is that I think lawyers should be attending that conference as well, not just financial advisors. And I think that we should have some kind of dating app linking solicitors and financial advisors up with one another, so that every lawyer has a financial advisor on speed dial and is able to just quickly call them up for a quick kick of the tires about a point, so that they can then understand whether or not they need more formal advice. So certainly my style of working is very much understanding the limits of the lawyer's knowledge and then moving out in a more interdisciplinary way. And I think lawyers should go out of their way to buddy up with good financial planners and to be ready to ask those questions. I don't think any question is too stupid. One other thing I would just very briefly like to mention, I commend the work that Jonathan does. If I open up a brief and I find a Mathieson report, I'm always delighted, particularly with the executive summary on page 1. But they're always very, very good quality, high quality. All pension experts' pods are not equal. And I think people do need to understand that. I'm aware of some pods in the market who have provided reports which, quite frankly, have not assisted the case and have made it more difficult. There's been the occasional case where I've said, look, you're just going to have to tear this up and go and see someone who is going to give better quality advice than this. And I think one of the difficulties that family lawyers face is kind of divining which experts it's appropriate to instruct as a POD and which ones is not. And I'm afraid I can't say anything more than that, obviously.
No, thanks, Rhys. I'm conscious of the time, but I think certainly it's that sentiment you talked about working together is one that I would like to take away today myself, and I hope everyone else does, because I think working together we absolutely can do more for our clients, which is what we're all here for at the end of the day. So thank you everybody for joining us. It's been a pleasure to host this panel webinar for you today, and we're grateful to you. So thanks very much and have a great afternoon.